because I can smell alcohol, so.
You're wrong.
Keep going. Stop.
Sorry?
Are you going to participate in any other kind of testing?
No, sir.
Based off, if you didn't do any kind of observation test, I had enough to arrest you and place you under arrest for DUI. Okay, so you'd have been going to jail.
You would have got sued.
That's qualified immunity. I wouldn't have got sued. But don't tense up. Why though? I'll explain that in a minute.
Yeah, I don't know why.
Quit trying to pull away from me.
What crime?
DUI.
DUI?
Yes.
I'm not under the influence.
He called the police after becoming the victim of a neighborhood crash. Minutes later, the investigation took an astonishing turn, and the victim found himself in handcuffs, accused of driving under the influence.
Okay, listen. I'm not disrespecting.
If I get a PBT, we blow into it?
Yeah, absolutely. Okay. And then I can go?
No, not yet. I'll get it in just a minute, brother.
What began as a simple traffic accident quickly became something much bigger. Officers arrived expecting to document a minor collision, but before long their attention shifted away from the teenage driver who caused the crash and onto the man who reported it.
Keep going, keep going, keep going, keep going, keep going. Stop.
Right.
Alright, are you going to participate in any other kind of testing?
Sorry?
Are you going to participate in any other kind of testing?
No, sir. I'm going to be making a phone call as we speak. What's your name?
Bell, it's right here.
Okay, what's your name?
Sergeant Earl.
Okay.
If he shows up, he's a witness, so he can't represent you anyway.
To clear up any doubts, officers requested a preliminary breath test. Confident he had nothing to hide, the driver agreed without hesitation, believing the result would end the investigation.
So is he going to do it? I don't think so. You did leave the scene of an accident.
So if I do them, are we good? Like,
and if you're not impaired, you'll pass
brother,
the
I
test,
swear to God,
and
I'm not.
everything's fine.
Okay.
But if not, then we have to.
Okay, then let's do it. I don't give a okay?
All
right.
Just that easy.
Officers asked if he would take standardized field sobriety tests. While he questioned their necessity after the breath test, he agreed to cooperate. However, continued detention must still be based on reasonable suspicion, as per the Fourth Amendment.
We're good? I'm all,
Is it enough right here?
Yeah.
I'll go straight up. Okay. So with these tests, nerves, tiredness doesn't play any play into it. What
I'm definitely nervous.
Okay, so what I'm looking for is involuntary move of the eyes. Nervousness, drowsiness, it's not something you can practice. What it does is something in your system that causes it, and it's a sign of impairment. Okay, it's called horizontal gaze nystagmus.
Yep.
Okay.
The first examination focused on horizontal gaze nystagmus. Officers explained they were looking for involuntary eye movements associated with impairment. The driver insisted he was only nervous, but nervousness alone is not generally recognized as proof of intoxication.
Yes, sir.
Alright, so you're not willing to do any other tests?
I mean, what do I got to do, brother? I'll do them. Like, I don't. What do I got to do?
Well, there's two more observations.
Okay.
One's called a walk and turn, the other one's one leg stand. Are you willing to do those?
Sure. 1, 2, 3, 4, 5, 6, 7, 8, 9. Spin around. Correct? 1, 2, 3, 4, 5, 6, 7, 8.
Okay.
Next came the walk and turn test. Following each instruction, he carefully counted every step before turning exactly as demonstrated. These standardized exercises are designed to identify specific clues, not to judge whether someone performs perfectly.
25, 26, 27, 28, 29, 30.
Okay. Oh, man.
Yep.
So you've not had anything to...
Brother, what do you think? I've told you this 8 times.
I know what I think. I want to know what you think.
I'll tell you what it is now.
Okay.
And I want your badge numbers whenever you guys are done.
It'll be on the citation I'm going to give you.
Good. Citation for what?
I'll explain all that when I give it to you.
Okay.
Okay. Was it that hard? We got
No,
through
brother,
everything.
I'm not trying to be a dickhead. I got shit to do.
I understand that, but here's the thing.
He then completed the one-leg stand, balancing while counting exactly as instructed. Throughout the encounter, he continued asking a simple question. If he completed every requested test, would this investigation finally be over?
Based off, if you didn't do any kind of observation test, I had enough to arrest you and place you under arrest for DUI. Okay, so you'd have been going to jail.
You would have got sued.
That's qualified immunity. I wouldn't have got sued, but okay. Again, I'm going to go over and I'm going to write you a ticket. I'm going to finish getting their information.
What's the ticket for?
I'll explain it to you when I give it to
Can you
you.
explain it now?
No, I'll explain it to you when I give it to you.
After the exercises, the driver maintained he wasn't impaired, attributing his anxiety around law enforcement to nervousness and exhaustion, which shouldn't be mistaken for intoxication. Courts recognize that ordinary nervousness during police encounters does not establish probable cause.
So remember I told you the stuff's going to be on a citation? Okay, it is. But also, after speaking with another officer on scene, you are going to end up going to jail tonight, okay?
Why?
Nah, put the
All
phone down. Turn
No,
around.
hold on.
Turn around.
Turn around, put your hands on, figure out it. I'm gonna tell you what.
Why? Why am I going to jail?
Don't tense up.
Why though?
I'll explain that in a minute.
Then, everything changed. After a private conversation between officers, one returned and unexpectedly announced that the driver was going to jail. Confused, he repeatedly asked why. Instead of receiving an explanation, he was instructed to turn around and place his hands behind his back.
You're
Hey
under
Carol, I'm going to jail. Yeah, I don't know why.
Quit trying to pull away from me.
You got that your body cam on for sure. Okay. Good.
Got anything on you that's going to poke, stick, stab me?
No. What's the point of the hat?
You're going to jail, you don't need it. I'm rolling over this car.
Okay. I need my phone, please, sir.
Nope.
The officer arrested the driver for DUI. Shocked, the driver pointed out that he had passed the breath test and all sobriety exercises. The sufficiency of these observations for establishing probable cause would later become a key legal question.
All right, sir, so what's going to happen is you're obviously going to jail tonight. We're impounding your truck. So it'll be at the Grayson impound. The registered owner.
I can't have my cousin. I live at the end of the street.
No, it was using the commission of a crime, so it's going to the impound lot.
Of crime. What
A
crime?
DUI.
DUI?
Yes.
I'm not under the influence.
Okay.
Is that literally what you guys are arresting me for?
One of the reasons.
For under what circumstance?
What do you mean, what circumstance?
Like what did I blow on the test?
There's
There you go.
many more than that. That right
Okay,
there-
test me.
Officers took him to jail and mentioned that further chemical testing would be requested. The driver requested to consult his attorney before deciding on a blood test. Implied consent laws often pose complex legal issues, particularly when constitutional rights and state procedures collide.
That's where we're going. We're going to go to Kenny's daughters where I'll read you some information, request to submit to a test your blood.
Actually, I'm not doing without my lawyer.
Okay, that's fine.
Okay.
But I still got to take you down there.
Okay.
So the registered owner of that vehicle,
This is my cousin.
they'll be at the ones go to the impound lot tomorrow and get it out. But they'll have to have all the information with it, okay?
I want Charles Badge number.
Okay.
Yeah. Right there, yeah.
Yeah, you right on that. You know, work these. Yes. You have to turn these off.
That raises an important question. If the breath test was 0.000 and the field sobriety tests had been completed, why continue down the path toward a DUI arrest? Was this simply a mistake, or had the focus shifted from evidence to asserting authority?
What is it?
That is the owner of the truck. The guy in the car right there, that would be the owner of the truck.
Well, it's going to the impound.
You can pick it up at the city impound lot tomorrow.
What now?
You can pick it up at the city impound lot tomorrow.
Okay, what's going on?
I mean, unless he tells me it's okay to tell you, I can't tell you.
Oh, okay. Well, was dead in a dead sleep. I've been up like all night, and Mommy came and got me, and she said he's getting locked up for wrecking or something. Did he wreck?
Well, he did wreck, but that's not the main reason he's going to go.
He just curved me to death. Well, I'll pick it up tomorrow.
His truck was impounded, and he spent the night in custody while continuing to insist he had done nothing wrong. By this point, the roadside encounter had evolved into something far more significant than a routine DUI investigation. It had become a dispute over whether the evidence truly justified depriving someone of their liberty. Every officer has a duty to remove impaired drivers from the road, but that responsibility must always be balanced against the constitutional protections guaranteed by the Fourth Amendment. Whether this arrest was supported by probable cause, or whether it crossed the line into an unlawful seizure, would soon be examined in court under oath. In our next update, we'll break down the courtroom testimony, the officer's own statements, the judge's rulings, and how the DUI charge ultimately unfolded. You won't want to miss what happened next.